All right, Nexon has sued Dark and Darker devs for copyright infringement in the gaming world. So this has been a bit of a news story for those of you who pay attention to gaming news with this copyright infringement lawsuit. A lot of interesting issues. It looks like more like bullying than copyright infringement, but they are suing for the copyright infringement, demanding a jury trial. So all that good stuff. Dark and Darker's legal drama is extending into the United States weeks after the feud went public. The Korean game publisher Nexon is suing Iron Mace over copyright infringement, demanding a jury trial, and two of the higher-ups are also individually named in the lawsuit. This comes just as Iron Mace releases a playtest for Dark and Darker via torrent, having been booted off Steam in relation to the copyright infringement claims. Iron Mace has yet to publicly respond, but it doesn't seem to defer the developer from continuing with the beta. In the lawsuit, Nexon isn't just trying to ensure Dark and Darker halts development and public distribution, but also calling for monetary damages for the copyright infringement. The amount the company's asking for would make up the money it says it's lost while developing its own game, P3, which claims Iron Mace stole to make Dark and Darker. So we got a whole bunch of issues here. We got misappropriation of trade secrets and copyright infringement as ideas. All right, so let's discuss some of the law that's going on here and some of the issues. First of all, let's discuss basic legal principles. No one owns an idea. No one owns an idea. So if someone has an idea and someone's like, "Oh, that's a good idea. I'm going to go do the thing." You can't sue for that, right? You can't sue for the idea. Now, to the extent that you're taking code, to the extent you're taking graphics, to the extent you're taking sounds, to the extent you're taking assets that belong to the company, then you have a real problem. That would be the misappropriation of trade secrets idea. You took our code, you took our graphics, you took our sound, you took our other assets. But you took our idea, not so much. So the question might be, all right, where are we in this dichotomy? Is it true that they took code or not? Is it true they took graphics or not? Of course, for their part, the people that are behind this game say no, they didn't do those things. So they say that they built the code from the ground up. So we have a dispute of fact as to what's going on. So I suppose we'll have to learn more. Condoning the defendant's conduct would threaten Nexon, the video game industry, and all consumers who enjoy playing sophisticated video games. Video game developers would not be able to invest years' worth of person hours into developing video games that their employee could simply transfer the employer's project files to their own personal servers. If they did that, that would be a problem. You can't take the project files. The project files belong to the company. If you did that, those employees did a bad. If those assets or that code then wound up in the infringing thing, then that would be a bad. You can't do that. Two Iron Mace employees named in the lawsuit are former Nexon employees. This is how Nexon says they got their hands on the source code and other assets, which they then claim those assets were transferred to Dark and Darker. On top of that, it's claimed that they're trying to convince employees to leave and join Iron Mace, but that's legal. You know, as long as you're not talking about a breach of contract, and almost all these things are work for hire, people can leave or not. It's just competition. So trying to say, you know, hey, do you want to come work for my company? That's not illegal. Taking the assets, though, might be a problem. They also allege that there's a 1-year non-compete contract, although those are sometimes problematic legally. And for what it's worth, the FTC, completely unrelated to the story but contemporaneous, is taking a look at non-competes in general and thinking about maybe some sort of federal regulations as it relates to non-compete agreements, because these things tend to be a problem. A 1-year non-compete wouldn't be completely atypical and would typically be upheld, but they can be a bit problematic on the details. Even as news of the lawsuit circulates, the defendants haven't responded publicly Although it's very possible, of course, they haven't responded because their lawyers told them to shut up. This is just a straight question of fact at this point. It is a straight question of fact as to whether Darker's devs took code or other assets from their former employer Nexon. If they did, that's a problem. If those codes or assets were then used and imported, then that's a problem. So there's a factual dispute here. But what they're alleging would be illegal. So the question is that what's going on, or are they simply trying to stomp down on competition? Which side of the factual dispute we're on? So something to pay attention to, and that's what it goes on for now.